identical to the resolution we consider, 280.
The whereas clauses are not identical, but the provision on line 35 through 38, commonly known as the repeal amendment, is, to the best of my knowledge, word for word identical to what the subcommittee considered when it looked at it.
Okay. Well, what can you tell us, before you start, can you tell us a little bit about what's different with the whereas?
The whereas clauses really go a little bit more into the purpose and necessity for this amendment. I think the Senate version was a bit more abbreviated, but we talk about what I'll summarize and say federal overreach and micromanagement of what goes on in states and localities. The historical reference to Alexander Hamilton's Federalist number 85. So it's a little bit more background, more of a wind-up to say, okay, therefore it would be this, what would become the 28th Amendment to the U.S. Constitution.
Okay.
I understand the subcommittee is somewhat familiar with this, having considered it previously, so maybe just touch on some points that maybe had not been previously considered about the necessity for this amendment. It really is the coincidence of two things. It's the fact that the federal government has expanded by, at least in terms of inflation-adjusted federal spending, by a factor of 5 or 6 in the last 5 decades. But Congress still has 535 members. So there's unlike maybe 50 or 60 years ago, when in a given congressional cycle, committees of Congress could actually bring executive people from the executive branch to Capitol Hill, conduct the oversight that they needed to conduct, repair, update, modify, change budgets as need to. The federal government today is just too big for them to do that. And while it's important who we elect and parties can change, and I accept that point, that does make a difference, there's still only 535 of them. And they simply don't have the time to look at overseeing the government that's been created, especially those programs that are passed down to the states and localities, which in many respects are just invisible to Congress in the 21st century. Combined with something that happened nearly 100 years ago, and that was the passage of the 17th Amendment, something I thought was a good idea then, still a good idea now. It provided for a significant enfranchisement of the voters in the form of direct election of U.S. senators. Well, what we lost in that, the unintended consequence of that, was the fact that state legislators could no longer have a direct relationship with their senators. One person who testified on the House side said, imagine if we still had that. Senators Warner and Webb might be walking the halls of the General Assembly building here asking, how's it going? Anything we can do for you in Washington? Any problems we can solve for you? Any federal overreach that we might address? That, of course, no longer occurs. So it's the combination of that and the substantial increase in the size of government that leaves us with a lot of federal programs that are simply beyond review of the federal government. I'll just touch on a couple of examples. Won't take your time with the long list. The House and Senate last year, the 2010 session, acted to consolidate and eliminate unnecessary reports that many of our school boards had to file in Richmond every year. There were more than 90. Got a report from the Board of Education about the progress that they've made. There's still 34 that they can't touch, all required by the federal government. I don't think anybody woke up in Congress one day and said, let's go mess with the school boards and create 34 reports. It's the unintended consequence of the accumulation of law after law over the course of time, never gone back to review to say, okay, what's really happening in the real world? How can we fix this? We have testing that is conducted in our schools for standards of learning. Those generally occur in May, but in no case later than the 8th of June, even though our schools go for sometimes 2 or 3 weeks into June. Why? A federal law says we have to take that data, aggregate it, and send it to the places it needs to go in time to meet that federal requirement. That's crazy. We're losing 2 or 3 weeks at the end of our school year to comply with that with no remedy. I could go on through transportation issues. We have a bill related to putting down quiet pavement that VDOT's working on. Hopefully that R&D will be finished in the next year or two. We wanted to say in 2013, could you start putting that into contracts? Got a letter from the Attorney General's office just last week. Can't do that because you're going to need permission from the Federal Highway Administration first. So those are the kinds of things that really, it's at that level. It's not the big issues of our time where elections are won and lost. It's the things that are out of view of Congress that we see as state legislators. We see this dysfunction that the repeal amendment is intended to correct. The idea here is to create a partnership between states and the federal government to look at these things and get them solved, not an adversarial relationship between state legislators in Congress. A couple things about what it doesn't do and is not about. It is focused only on the laws, federal law, U.S. code and regulations, not treaties, not another way to amend the Constitution. Some have suggested that this is another name for a 19th century unconstitutional idea called nullification. That's not what this is about. Under the repeal amendment, all the states are in, or all the states are out. This is not a one-state opt-out kind of thing as people attempted to do back then. Others have suggested that because 34 states could pass an amendment repealing a federal law or regulation, that this is a concern because mathematically 34 states could represent less than half the people. Nothing new or tricky here. 34 states by the representation in the U.S. Senate today can veto presidential, can override presidential vetoes, approve treaties, remove the president and other officers from office. In fact, according to the Senate's rules, not the Constitution, the cloture rules, 21 of the smallest states can block action on any law that's coming through Congress. So this is not a new idea or something tricky we put in here. We really just tried to adopt things that are already in the Constitution. And beyond that, there's nothing inherent in the repeal amendment that's biased towards states based on size. It's just an overall look at any federal law or regulation. We looked at whether we should make it more limited than it is. Okay, we're not talking about amending the Constitution or a new way. We're not talking about treaties. Should it just be a certain kind of law, a certain set of laws? And the way we came out was, as you see here, and the reason is we didn't want to put in provisos that if the amendment ever became part of the Constitution, the first thing that would happen if the states wanted to act is we'd all end up in court trying to figure out whether the states had the right to repeal that one or not. We thought that that was not going to be productive. So that's why you see it written the way it is. And the other thing is for the major issues, we realized that voters would be unlikely, in fact, in my view, impossible to elect members of Congress to safeguard what I'll call settled law. We can go through all the things that might be, but at the same time elect state legislators to unwind those provisions of settled law. That doesn't make sense in the minds of, or would not make sense to suggest that the voters would want to do that. Instead, it draws attention to the things that are invisible to Congress because they created a government that is in fact too big for them to effectively legislate and oversee. That's the problem that's new in the 21st century that we didn't have, and the need for the amendment. A couple final points on process. This is an Article 5 application. You see the word application on the top. Some have expressed concern that if we had a convention, it could not be contained, and it could come up with a lot of crazy things. A couple points on that. The convention that started or wrote the Constitution in 1787 was not the only convention of its time. There were at least 10 conventions from the time of the Declaration of Independence to 1787 in that 11-year period among states, from 3 to 12 states, to look at specific issues. Legislatures sent delegates to those states, in some cases with very limited specific authority to act on even one purpose. Others were more open-ended. But it was certainly understood by those who wrote Article 5 that conventions could be limited because they were at the contemporary period of time. They looked at issues like cooperation and militia between states, commerce between the states. So that was not a novel idea for them. It shouldn't be a worrisome idea for us now. Related to that, at the state level, all 50 states have constitutions. Many have been rewritten over the course of time. We've actually rewritten state constitutions 137 times in the course, and included in the original 50 constitutions. Virginia is on its. Yeah, Virginia is.
How many times have we changed state constitutions?
Virginia is on its 7th. Okay, and then we can all say that with the benefit of hindsight, some of the earlier drafts, including our U.S. Constitution, is far from perfect. But I don't believe there was anything crazy that happened at these conventions. There's nothing in Virginia history or elsewhere to say we had a runaway convention, something that we would look back and say we just can't do this kind of process again. We wouldn't trust ourselves. And in fact, 14 states today have provisions in their state constitutions that put a referendum on their state ballots once every 10 or 20 years to ask the voters, do you want to rewrite the Constitution? We had 4 of those just this past November. 3 of the states said no. Maryland actually had a plurality that said yes, because they needed 50% plus 1. They're not going to do that. But that's in the ordinary course of business. We kind of comes and goes. Nobody's particularly excited. The last point I'll make is whatever would come out of a convention, just as whatever would come out of Congress in terms of a constitutional amendment, has no standing unless ratified by 38 states. 76 different votes of houses of legislature. if a convention ever came out with something wacky, I'm very confident that the people around this table and our counterparts in 49 other states would say, you know, we're just not going to do that. That's a huge safety valve on this process, and one that we ought to have considerable confidence in. So, in summary, we propose this not to create an adversarial relationship. This is not an attempt to bang Congress over the head, poke Washington in the eye. It's to reinstate the kind of oversight of federal law and regulation, especially those things out of view of Congress that have been thrust out of the state, so that we can make these laws work, eliminate them when we need to. Frankly, the threat of this, I think, would frankly cause Congress to clean up its act, and certainly act as a preventative measure for Congress to think twice before it continues to overreach and micromanage what we can do better at the state level. Be happy to answer any questions.
I realize, Dudley, you were elected in 2009, but are you familiar with HJ542 from the 2004 session?
I'm familiar with one of your co-pages, House of Delegates.
Delegate Landers.
The House and Senate took a contrary action a few years ago.
And they repealed all requests for federal constitutional amendments. And in that resolution, it said, whereas the operations of a convention are unknown and the apportionment and selection of delegates, method of voting in convention, and other essential procedural details are not specified in Article 5 of the Constitution of the United States. Now, that seems to me to be a very contrary view to the one you just stated. And I wonder what's caused the sea change over the last 7 years.
I'll give you two reasons. One, I think just the recognition that maybe wasn't recognized at that time, that at the state level we do this in a way that I would even call ordinary and customary, updating our constitutions. I'm not aware that that was actually thought about or considered at that time. And secondly, this idea of other conventions around the time of the Declaration of Independence, 1787, is really based on new legal research, in particular by Professor Robert Nadelson, previously at the University of Montana, who's actually looked at founding era original documents to look at these questions in particular. What were they thinking when they wrote Article 5 the way they did? Did they really contemplate the idea of a limited convention? And the answer is yes, and that information, frankly, was not available.
Okay, are there other questions in the Well, are there those in the room who would like to speak in favor of this bill? Okay, form a line and
We'll be brief. Mr. Chair, members of the committee, Chris Friend of the Family Foundation, we do support this amendment. And I think it's important, particularly to note in Delegate Money's presentation, I think this is going to be effective in dealing with smaller issues that the federal government comes up with that cause problems for the state. Even on health care, which is a hugely divisive issue right now. I believe only 27 states have signed on to the legal challenges. It hasn't even gotten to 34. Now that there's been a couple of victories in the courts, you may see some other folks join on, but it's a difficult hurdle. So I don't think you have to worry about massive changes in federal laws. This is going to be for things that really, as we said, the federal government cannot possibly understand the implication of the states because they don't have that relationship anymore. I think that's what we're really concerned about and why we support this.
okay, well, thank you, Mr. Fender. Are there questions for this witness? Okay, thank you. Yes, sir.
Mr. Chairman, Andrew Lamar, Governor's Office, just to say that the Governor is very supportive of this as well, and wanted to be here to let you know. Thanks.
Thank you. Any questions? Okay. Yes, sir.
Hello, my name is Joe Garino. I'm the chairman of the Legislative Committee with the Richmond Tea Party, which is part of the Virginia Tea Party Patriots Federation. The Richmond Tea Party has about 8,000 supporters, and then approximately 40 Tea Party groups across Virginia, part of the Federation, representing about 35,000 individuals. Now, heard a whole lot about what's going on with the Tea Parties. We do not always agree. We're very independent. We just have a loose federation. And not everybody agrees on this amendment, and this amendment resolution, and I think that's probably well known. What I'd like to talk about is how this resolution, if it were to go forward, really cuts both ways, and I think it really could be at an advantage for both parties. Okay, right now in this environment, I think a lot of us are looking at this vis-a-vis the Patient Protection and Affordable Care Act. Okay. But I'd like to think about the future, especially for folks who consider themselves part of the Progressive Party. And that is, what if, for example, natural resources. Senator Northam, I know that you were born on the Eastern Shore, and so with Chesapeake Bay. What happens if maybe in a few years conservatives get in power, they pass a law that you find anathema to the Chesapeake Bay, And, well, it turns out that there are a lot of folks across the country that feel that way, and the tide switches, and now we have the Progressive Party, the Democrats that are in charge, and they're able to use this amendment to repeal that nasty law that impacts the Chesapeake Bay. That's an advantage for you by supporting this resolution right now. If Senator Whipple were here, I mentioned to her, I said, what if there were a law passed by the Republicans now that really hurts immigrants, especially with all the immigrants that are up in Northern Virginia? In a few years, the tide may change, and she and other legislatures across the country could seek to get that law overturned. In urban areas, especially Senator McEachin, with you being here in Richmond, what if the conservatives and the Republicans passed a law on gun control that you didn't like? And then again, the tide changes. This resolution could be used in your favor in the future to overturn something like that. So I'd just like you to think about that as we move forward, that this is not a Republican or Democrat issue. It cuts both ways, and I'd like to encourage you to support this resolution.
Senator Martin has a
Just a
question.
couple quick questions. I mean, I think I know what you're trying to say here, but why should we be considering how an amendment to the Constitution affects our respective parties? And I'll just ask another question in there at the same time. Why wouldn't I, who love the Chesapeake Bay and enjoy spending time working fishing on it, and want there to be as many fish there for me to catch as possible, want to protect the bay just as much as Senator North as a Republican versus a Democrat? Why would that be a partisan?
Well, I think a lot of the issues that we deal with are political, whether we like it or not, and that's what this environment is all about. And we never know which way the tide is going to change on a multitude of issues. And I just think that that by presenting this resolution to Congress and having other states joining in, and ultimately having an amendment convention for the one particular purpose that's spelled out in this resolution, would give both parties an opportunity to take advantage of it in the future.
Thank you. Are there any additional questions for Ms. Wicks? Thank you, Mr. Green. Thank you.
Thank you.
Yes, sir.
Yeah, Mr. Chairman, I'm Craig DeSessa, and I represent the Middle Resolution. And
What's the name of that group? I'm sorry.
the Middle Resolution, okay? And Delegate Lemonnion, I want to thank him for the excellent explanation of this bill. And I'm not going to waste our time with reiterating all the good points that people have made. What I want to discuss or share with you are my thoughts about the process. I was in the full committee the other day, and I watched the debate. It wasn't about the amendment. It was about about tradition versus the rules.
Well, you know, we're in this subcommittee, we're talking about this amendment, and the amendments, and talking about the things that are on our docket. Right now, we're talking about SJR 5, or HJR 542.
That is exactly where I'm going.
Okay, well, I appreciate it.
Okay, so we all know what happened in that committee meeting. There was this debate about tradition versus the rules, and I thought Senator Obenstein did a great job expressing the fact that it is the rules of the Senate to allow the full committee to take final action on an amendment, or on a bill, excuse me. And that didn't happen. Senator Howe took the final action on the committee by not allowing this to be debated. So I would encourage this committee here, this subcommittee here, to go ahead and recommend this to be debated at the full committee, because first of all, that is the rule. I would hate, well, let me say this. I'm guessing that everybody on this subcommittee would never have wanted tradition to trump the rule of law in the case of slavery or suffrage. So I encourage everybody to allow this to have full debate and let's follow the rules of the committee.
You don't have anything to say about this particular
Well, I just did. I said I agree with everything Senator Lemonnion, or excuse me, Delegate Lemonnion said.
Okay, thank you, sir. Okay, are there others who would like to speak in favor of the amendment? Are there those who have a different view?
Yes, sir.
Please come forward and state your case.
First of all, each
Could
member...
you tell us who you are?
Oh, I'm
Where
sorry.
are you from?
I'm Joe Key from Chesapeake. I'm not very important, just concerned about this item. Each member of the General Assembly received a CD like this one here, and most of the members have not considered it. We also have a DVD, which is the same thing with pictures. All right, this was sent to everyone.
Okay,
Now,
describe for us what that is, what you're...
this is a presentation by constitutional specialists, researchers, and the DVD and the CD were produced specifically for state legislators. I'd like to honor Senator McWaters with that particular copy.
Appreciate that. No
And,
charge, sir?
In turn, I would like to take advantage of his hospitality, which he doesn't know
Mr.
very
Chairman,
yet.
that really should go through the clerk and not be
Yeah.
built out like a set of cards.
And I'd appreciate it.
Yeah,
It's not handed to the clerk.
All right. Okay, well, that's for each one of you to consider, and if you'll notice on page 29, the crux of the matter. Now, all of these flowery statements that have been made in favor of constitutional convention or passing this resolution do not apply. You guys should be objective and realize they do not apply.
Excuse me, Mr. Key, you're handing out McWater's campaign material?
No,
here?
sir, no, sir, no, sir. Page 29 is, page 29.
Give both of them, Mr. Chairman.
And by the way, I'll collect them and return them to him after it's over. But on page 29, it gives you the crux of the matter, everything that you should consider. All this stuff, these statements are just out in left field. They do not apply. What does apply is the only rule that concerns this subject matter. It is Article 5 of the U.S. Constitution, page 29. It says the portion which is underlined in red, the rest of it is not applicable really. The Congress, on the application of the legislatures of 2/3 of the states, shall call a constitution for proposing amendments. That's all you're voting on. You're not voting on stopping a constitution. That's not possible.
So it'd be fair to say, Mr. Key, that you would agree with that portion of HJR 194 that I read, the operations of the convention are unknown, and the apportionment and selection of delegates, method of voting in the convention, and other essential procedural details are not specified in Article 5 of the United States Constitution.
A fair reading of what I just underlined and read and gave to you guys would answer that question. Absolutely, you have no control once you call a convention. Just remember, your vote today is whether or not to call a convention. All this stuff about what a convention will do is immaterial, although most of it I support, by the way. But you must not go the route of a national constitutional convention. If you want to get a legally proposed amendment to the Constitution, the Congress of the United States is your place. And I
apologize, Mr. Key, do you speak for yourself or you for the group?
I'm a member of the Virginia Constitutional Convention Rescind Committee. We're the ones who pushed HJ or something, 194 in 2004. We researched that thing for 15 months before we came up here in 04.
Well, I appreciate that. Are there any questions, Mr. Key?
Mr. Chairman, I just would repeat, thank you for the handout material, because
Did you want to leave it or you collect it?
I'm not sure.
None of us live in your district, none of us can vote.
Mr. Chairman, I just would say, this, I don't want to be a broken record, I said it earlier, and I said it last week when we met. This is an important issue, and I would hope that we could pass this to the committee to allow this to be debated in the open committee. Thank you.
Okay. I appreciate it, Mr. Key. The next speaker.
Okay. Tom Redfern from Petersburg, Virginia. The Articles of Convention, for the sole purpose of that convention, the Articles of Confederation, the sole purpose there was to revise the Articles. Of course, we ended up with the Constitution. 13 states were required to have that go into effect. Couldn't get 13, so they took 9. So they changed the rules on that. In 2004, as the chairman mentioned, HJ 194 was passed. The purpose of the bill was to rescind, quote, rescind and withdraw all past resolutions of the General Assembly applying to the Congress to call a constitutional convention, end quote. Some of these calls have gone back into the 70s, balanced budget, and come other things. There's multiple ones. Why? One of the whereases, quote, the operations of the convention are unknown and the apportionment and selection of delegates, comma, method of voting in convention, comma, and other essential procedural details are not specified in Article 5, end quote. Now, I don't know why 31 members of the House have reversed their position. 30 members of the House voted for a Constitutional Convention this time that were against it. Remember, the vote was 91 to 5 in the House, 2004, 37 to 0 in the Senate. In seeing the dangers of the convention in 2004, Virginia became one of 16 states that rescinded and withdrew the previous calls for an Article 5 convention. They realized the call for convention was not a thing of play. Newly enlightened proponents of convention focusing a lot on emotion. Please do not support the call for a convention and vote against HR.
And I appreciate,
42.
do you speak for yourself, Mr. Redford, or for a group?
I'm with the Virginia Contown Rescind Committee.
Okay. So the same
well,
committee?
yeah.
Same.
But it's individual,
Are
you
there
know.
questions for Mr. Redford? Are there others who would like to speak on this matter? Going once. Okay, we operate on motion.
Move that the resolution be recommended to be reported, and Smith seconds that.
Got a motion and a second that the
Mr.
resolution
Chairman,
said we teach.
substitute motion to pass the bill by indefinitely.
Second.
Okay, substitute motion takes precedence. All in favor? Is there any discussion? All in favor of the substitute motion, say aye.
Aye.
Senator Whipple says aye. All opposed, say no.
No,
Okay.
and so the other
Ms.
two.
Waters and Smith, so thank you very much. But you can go to jail for the board.
Thank you, Senators. Appreciate the time.
Okay. The next one,